The suspected middleman in the Transnet Regiments Capital and Trillian corruption saga is appearing at the Palm Ridge Specialised Crimes Court. Let's take you live to that.
Anyway, Your Worship, from the UK representing both the accused before court.
Thank you.
As the court pleases, Your Worship, as my learned friend for the state indicated, the accused was arrested yesterday evening on a J50 warrant issued yesterday by Magistrate PJ no relation from Johannesburg. Was at the OR Tambo airport on his way to Dubai on a return trip. The details will be placed before court later. And the accused is then on a first appearance before this honourable court today. Your Worship, we intend bringing an application for bail. We are ready to proceed with an application, Your Worship, from the charge or the draft charge sheet made available to us by my learned friend for the state. This clearly resorts under Schedule 5 of the Criminal Procedure Act. The onus, therefore, is on the applicant to prove that the interest of justice will permit his release on bail. We are ready to proceed to do so. Could Your Worship hear my learned friend for the state, whether she in fact is ready for the application to proceed, as the court pleases.
Thank you, Your Worship. As indicated in my initial address, this is indeed a Schedule 5 letter. It's correct, Your Worship, that the accused person was arrested yesterday with his way to Dubai. We were notified yesterday because he has been flagged for some time now. Upon him having booked the flight ticket, this is how our investigator hint of the fact that the accused person was about to board a flight to Dubai. We, having executed the J50 yesterday, I've communicated earlier today with my learned friends that we are not in a position to resume with our bail application today. We will, however, be in a position to reply to them at the earliest on Friday, Your Worship. If they wish to start with their application, I will not have an objection. Ideally, we would have preferred that we deal with both our applications on the same day. I will leave that to the court to exercise its discretion in that regard, Your Worship. There are a few outstanding aspects that we still need to look into. The reason they are not looked into today, right now, Your Worship, is because we were only informed or notified yesterday by the red flag system that the accused was about to leave the Republic. Hence, we were not prepared to be before this court. As of yesterday morning, we were not prepared to be before this court today. So we have had to finalize our charge sheet and so forth so that we can bring him before the court today, Your Worship. But whether or not we both proceed today, that will be left to the discretion of the court. Thank you, Your Worship.
Thank you, Mr. Du Plessis. As to whether you wish to proceed today or not, I don't know if you have any indication whether you wish to proceed today and do the application today, and the state does the opposition on Friday.
Yes, Your Worship, at this stage our position is that we are ready to proceed and we wish to proceed. As far as my learned friend for the state's application is concerned, Your Worship, that will be opposed. This case has got a long history, and at the appropriate time, when once we have submitted our affidavit in support of our bail application. We will present evidence to the court relating to the history of this matter. My learned friend is very vague about the so-called aspects which they need to check on, and I submit with respect, Your Worship, that the state, in view of the history of this case, should not be granted a postponement at all. But let us deal with respect to that when we get to that issue. For the moment, may I request leave to submit to the court the founding application of the accused for bail in this matter. The original is handed up to Your Worship.
The applicant may be seated, please. Thank you.
Thank you. And may I request then leave to proceed to read it out on record?
Yes, you may. Thank you.
Thank you. It reads as follows. I, the undersigned Kubendaran Moodley, hereby declare under oath as follows. 1. I am the applicant in the above-mentioned matter, a major male aged 50, with the following personal particulars and background. Identification number. My identification number is 7108075115-083. Date of birth. I was born on the 7th day of August 1971. Citizenship. I am a South African citizen. Travel documents. I am the holder of a valid South African passport. Passport number M00353472, expiring on the 1st of September 2031. I will hand my passport to the investigating officer for safekeeping until finalization of the case, should the court impose such a condition. 1.3.2 Previous travel or residence in foreign countries. My most recent travels were inter alia in December 2017. I traveled to India for a vacation and religious reasons of 10 days. In August 2018, I traveled to Mauritius for a vacation of 7 days. In February 2020, I traveled to the Congo for business purposes 8 days. 1.3.3 Relatives residing outside the RSA. I have 2 aunts that reside in Canada, but I have not visited them in the last 15 years. They visit us in South Africa. I also have an uncle residing in London, but I have not visited him in the last 15 years. He visits us in South Africa. 1.3.4 Assets outside the RSA. I have no assets outside the Republic of South Africa. Personal background. Place of birth. I was born in Durban, KwaZulu-Natal, South Africa. Schooling. I successfully completed grade 12 at Brindhaven Secondary School, Chatsworth, KwaZulu-Natal, South Africa, in the year 1989. Tertiary or other training. I successfully completed a certificate in sales marketing at Daimler College, Durban, in 1996. I successfully completed a diploma in BBA Business Management at Natal Technikon, Durban, in 1997. I successfully completed a BSc degree in Business Management through the University of Wales in 1998. Work history from 1990 to 2012. I was employed at Telkom Durban and Pretoria in different positions, ending up as the head of channel management from 2012 to 2017. I was a director and shareholder of numerous companies of my own, specializing in property management, consulting services, and debt collection, which all were placed under curatorship as a result of allegations that I assisted the Guptas in alleged illegal activities. Since 2017 to date, I could not work due to what I say are false allegations that I was involved in criminal activities and is currently dependent, and I am currently dependent on my wife. General remarks regarding background and permanency. I've been living in Johannesburg in the Republic of South Africa for the past 21 years and have no plans or desire to relocate elsewhere. 1.5 current status, address. I am residing at 22 Robert Crescent, Morningside, Johannesburg. 1.5.2 marital status and general particulars of spouse. I am married to Devon Bushman Naidu since 2007. Dependents, I have 2 minor children born from the marriage. A son, Ryan, 13 years of age, a scholar in grade 7 at St. John's College, Johannesburg, and a daughter, Jamaica, 12 years of age, scholar in grade 5 at Radio College, Morningside, Johannesburg. Occupation, as stated above in paragraph 1.4.4, I am currently unemployed due to all the false allegations of criminality made against me in the media. Income from occupation, I do not receive any income at the moment and I am dependent on my wife. Other sources of income, I have no other source of income. Assets, these are only the main assets, Your Worship. The house I reside in is fully paid but belongs to a trust or a trust wherein my 2 minor children are the beneficiaries, valued at approximately 7 million rand. I have only a right of use. I am also the holder of investments valued to approximately 400,000 rand, but all of this is currently placed under curatorship and I therefore have no control over it. I am also a beneficiary of a trust holding Shana Park, KwaZulu-Natal, consisting of, that should read 11 units, which I inherited from my late father, valued at approximately 6 million rand, registered in the name of Desert Star Pty Limited. My wife is the sole director of this company. Availability and sources of funds for bail. I can afford to pay bail in a reasonable amount from funds made available by my wife and can raise repayable loans from family members. History of antisocial behavior, previous convictions. I have no previous convictions. Pending criminal cases. I have no pending criminal matters. Arrest and factual background thereto. Date of arrest. I was arrested on the 28th day of September 2021 at approximately 19 hours at the international boarding gate of Tambo when I was on my way with friends for a 5-day golf playing vacation in Dubai. Your Worship, I may just pause here to mention that the return air ticket will be presented for a copy thereof to the court. Offences charged with. I am informed that I am charged with fraud, theft, corruption and money laundering, the detail of which is not currently known to me. These allegations arise from investigations by various entities like the Zondo Commission and the Investigative Directorate of the NPA. May I pause to say, Your Worship, that approximately 3 minutes before Your Worship entered, my learned friend supplied me with a draft charge sheet, which even at the speed I'm reading, I couldn't peruse, but it comprises all of 89 pages, and she assures me that this is not complete. So we have not at this stage dealt with the facts of the matter. Offences charged with that I've read. Intended plea. I intend to plead not guilty. Defence. I have been informed of my right to remain silent at this stage and not to disclose the basis of my defence, which right I wish to exercise, save to deny all allegations levelled against me. and to reserve the right to respond to whatever allegations the state may make during these bail application proceedings. Submissions regarding factors to be considered when deciding whether bail should be granted. The schedule of Criminal Procedure Act 51 of 1977, the matter resorts under. I've been advised that the offence that I'm being charged with falls under Schedule 5 of the Criminal Procedure Act, and that I therefore bear the onus to convince this Honourable Court that the interest of justice will allow my release on bail. I am further advised that in considering whether to grant an application for bail, the Court will consider the relevant factors listed in Section 60 of the Criminal Procedure Act. Considerations in terms of Section 64A to E. Section 64A, danger to public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I do not have any disposition to violence and harbour no resentment against any particular individual or the public in general. I do not pose any danger to any particular individual or the community, and I have not displayed any inclination to commit violent crimes. Section 64B, likelihood of evasion of trial. I respectfully submit that this likelihood does not exist. I am innocent of what I am being accused of. I do not wish to evade my trial and live the life of a fugitive, and I do not have the means, financial or otherwise, to live the life of a fugitive. I will stand my trial with a view to clearing my name of any alleged wrongdoing. I have been aware of this investigation for years now and had ample opportunity to flee the country had I wished to. Section 64C, interference with witnesses or evidence. There is no likelihood of me interfering with the witnesses in this matter. I undertake not to interfere with any state witnesses, even if their identity became unknown to me. I have no access to evidentiary material held by the investigating officer. I will also not interfere with the investigation of this case if I am granted bail. Through the years of investigation, no such allegation of interference had been made against me. Section 64D, jeopardy to functioning of the criminal justice system or the bail system. Given all the above considerations, I submit respectfully that I pose no danger to the functioning of the criminal justice system or the bail system. I have not furnished any false information for purposes of this application or after my arrest. The investigating team by now knows all my personal information arising from the Zondo Commission and various court applications in terms of POCA. They were clearly watching me and knew about my planned trip to Dubai. It is astounding that if they had a prosecutable case against me, the authorities would wait for me to leave the country on a planned trip and only then effect an arrest. The only inference is that this is done in bad faith to cast aspersions on me that I wanted to flee the country. I take huge offence to these underhanded tactics and would have handed myself over for arrest in order to have the matter enrolled had I been notified of the need to do so. My full family, economic and social ties is in this, my country of birth, and I will not walk away from it because of a threat of prosecution, even if it starts to look more like persecution. Section 64E, exceptional circumstances, presence or absence which may lead to undermining public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to undermining public order or peace should the court decide to grant me bail in this matter. The provisions of Section 60 in brackets 9, close brackets, the interest of justice in relation to the right to be released on bail. I respectfully submit that I will be prejudiced in the event of being further detained. I also urge this Honourable Court to consider the period I am to be detained until this matter is finalised, and the fact that criminal trials can take a considerable period of time before it is finalised, especially a commercial matter of this nature, which is known to take years to complete in many instances. I also urge upon this Honourable Court that, should I be detained and refuse bail, that I would be prejudiced in the preparation of my defence. It is extremely difficult to consult with a legal representative inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for trial. Again, specifically relating to an involved matter like the present, which will no doubt comprise of tons of paperwork. In the premise and taking into consideration the relevant schedule the charges resort under, I respectfully submit that the court should grant bail to me in an appropriate amount and with such conditions attached as the court may deem fit. Your Worship, that concludes the affidavit by the applicant. May I request that it be handed up as an exhibit in the matter?
Thank you. Yes, I'll mark it as bail application Exhibit A. Thank you.
The court pleaser. Your Worship, at this stage, firstly, it is not clear to me whether the state really opposes bail, and if so, on which grounds. My learned friend did not confide in the court relating to that issue, merely mentioning certain aspects that the state wish to check, or certain information they want to access. Now, Your Worship, with respect, not knowing whether there are any real grounds of opposition by the state, the founding affidavit now handed up constitutes the evidence by the applicant at this stage. Obviously, these are application proceedings, and depending on what the state will present to the court, we will obviously or we may reply at a later stage to whatever the state may present. So at this stage, I will not present further evidence. However, may I request through the court that my learned friend indicates whether the state is at this stage able to say on which grounds are they opposing bail, if they are opposing, and on which specific grounds they are seeking a postponement in this matter, I believe, until Friday. I respectfully submit, Your Worship, that the issues which the state wants to canvass should be placed on record. There is no reason why it should be considered as privileged or secret. Let the state tell us what they want to check on, and perhaps the applicant can assist with paperwork or any further evidence which we may be in a position to present to the court as the court pleases.
Thank you, sir.
Thank you, Your Worship. Yes, it's indeed correct that at this stage we are opposed to the applicant's release or admission to bail. Your Worship, the state requests an opportunity to analyze and present before the court evidence from cell phone experts. That has already started yesterday already. We've sought assistance from the investigating directorate head to assist us, and earlier this morning when I conversed with her, she indicated that she is awaiting affidavits from cell phone experts in order to assist us in the application or the reply to Mr. Moodley's application to be admitted to bail. The other aspect that the state wants to look into, Your Worship, is in relation to Mr. Moodley's assets outside the Republic. It's indeed so that he has addressed this or canvassed this aspect in his affidavit. He says that he's got absolutely no assets outside. of the Republic, but the state wishes to look into this. If one listens to Mr. Moodley's application, he indicates that he was about to leave the country, going on a golf vacation with friends. In the same breath, he says that he does not have any income because he is no longer employed, and his bail would be funded by his relatives if or when the wife secures a loan from these people. Now, this raises a question of what assets does Mr. Moodley really have if he is a gentleman that can afford to board a plane to Dubai simply for the purposes of going on a golfing vacation, Your Worship. He was indeed arrested just as he was about to board a plane on a J50 warrant, as already indicated. He indicates further in his affidavit, Your Worship, that he is willing to cooperate and he would have handed himself over. Now, we were not aware that Mr. Moodley was about to leave up until we got the notification from the airport, Your Worship. So that then addresses the question that the point that he makes in his affidavit in saying that he could have easily been notified that we are ready to prosecute him. Your Worship, the reason we intercepted Mr. Moodley's movement is because we then when we became aware, it raised the question of whether or not Mr. Moodley indeed intended to return to the Republic, even though, yes, I see attached to his affidavit is the boarding ticket that also shows the return flight that was booked for the 3rd of October. Now, Your Worship, in light of these facts that the state has set out, the state submits that Friday, the 1st of October, is just around the corner, Your Worship. As I've indicated, we've asked Ms. Cronje to assist us with the cell phone expert reports in relation to Mr. Moodley's cell phone. They've indicated that he is going not to interfere with the investigations, but we are looking at the AFU application that was done, an AFU application that was done in relation to his assets, Your Worship. We intend to use some of that evidence to substantiate our application before this court. So I'm still trying to procure and gather all the evidence, Your Worship. This came before the court on a very urgent basis, and I agree that bail is indeed urgent. I had indicated earlier that we would make arrangements or ask the court to have Mr. Moodley detained at one of the police stations. I have been in contact with Johannesburg Central Police Station. Brigadier Perumal has indeed indicated that his station is willing to accept Mr. Moodley because this is a Johannesburg docket. So I'm just waiting for Brigadier Perumal to send through the email with the consent that they are willing indeed to house Mr. Moodley up until we return to the court on Friday. So at this stage, Your Worship, it is our submission that yes, indeed, we are opposing Mr. Moodley's release, as we fear that he is indeed a flight risk, Your Worship. But for us to substantiate and reply properly to the applicant's application, we require time in order to gather all our evidence so that we do not come to the court with half or piecemeal information before this honorable court. Thank you, Your Worship, unless if there's any aspects that the court wishes to hear me on.
Thank you.
Thank you.
Thank you, Mr. Duplessis.
Your Worship, may I just inquire whether the court is in possession of the warrant of arrest J50 signed by Magistrate Duplessis. I have a copy available if it's not attached to the charge sheet.
There's an awful lot of documents here. I'm not sure that if it's amongst these documents.
May I hand up a copy?
Thank you.
was supplied to us by my learned friend for the state.
Thank you. I'll mark this as bail application Exhibit B.
As the court pleases. Your Worship, relating to my learned friend's request for a postponement, obviously she is only allowed to bring such an application without the parameters of the Criminal Procedure Act, and the section dealing with that is indeed section 56, and specifically subparagraph D of the Criminal Procedure Act 51 of 1977. Now I will address the court briefly as to whether sufficient grounds have been established by my learned friend to convince the court with respect that a further postponement is warranted. But before doing so, I request leave to call Ms. Simone Meads. She is an attorney from the firm Paper, just briefly relating to the framework of this matter. She is present in court.
Thank you. Thank you, ma'am. Your full names, please. Have you any objection to taking the prescribed oath? No. You swear the evidence you're about to give will be the truth and nothing but the truth? Say so help me God. Thank you. You may continue.
Thank you.
Duplessis.
Just speak up, please, for the machines to record. You are a practicing attorney, is it correct?
That's correct.
Yeah. You have to speak.
That's correct.
From the attorney paper attorney's firm.
That's correct.
Have you been representing the applicant in this matter, Mr. Ben Moodley, on several matters?
I have.
And these matters are all relating to the matter we are dealing with in court today?
Yes,
correct?
That's correct.
Now, let me just ask you to briefly inform the court, and we may later present the court with court papers relating to these different procedures which are ongoing. Since when have you been involved as the attorney of Mr. Moodley?
I became involved towards the end of 2019. No, sorry, towards the middle of 2019, June, July, around there.
Yes. Now, there are several processes ongoing at the moment, of which one is a restraint order which is in place in terms of POCA.
That's correct.
Proceeds of Crime Act. Now, that matter I will need you, my learned friend can object if she sees the need to do so, but I just want to save time. According to the records I've been handed, this application was brought on or about the 11th of June 2020, and the order of the judge restraining certain assets was given on the 19th of June 2020. Correct?
We were in court the evening of the 10th of June, I would say 8-9 o'clock the evening, for the restraint application, and then that's correct, the judgment was given on the 19th of June.
Yeah. But the fact of the matter is the restraint application is based on the allegations made in this court against this accused, correct?
That's correct.
And the application for a restraint order was brought by the state, referring to the issues surrounding Albertine Pty Limited, the accused then Moodley, and the Regiments Group, etc.
That's correct.
Exactly what we are looking at in terms of the draft charge.
That's correct.
So already at that stage, all these facts were known to the state.
That's correct.
Now, then, on the 4th of November 2020, well, let me just pause for a moment. On or about the 14th of July 2020, the state chose to bring contempt proceedings against Mr. Moodley.
That's correct.
Which proceedings are the topic of a hearing at the moment. It's partly heard pending in the High Court.
Yes, that's correct. That's correct.
Due to proceed again on the 8th of October.
That's correct.
And that is relating to issues surrounding the restraint order, correct?
That's correct.
And in that application was also substantiated or supported by one of the Deputy National Directors of Public Prosecutions, who is heading the independent director, or the investigative director, rather, Ms. Hermine Teresa Brunier.
Yes, that's correct.
And in that affidavit of hers, she deals in great detail with this very matter we are dealing with in court today.
Yes, that's correct.
Factual background, etc., and the basis for the restraint, and the basis on which it is alleged that the applicant did not comply with all issues or all the aspects of the order made by the court in terms of the restraint order.
That's correct.
Then furthermore, there was a search and seizure warrant issued on the 4th of November 2020 and executed during that period.
Yes, that's correct.
And that also was based on the very facts we are dealing with in this court.
Yes, that's correct.
That and obviously the asset forfeiture unit activities, etc. Now, once again, that was substantiated by and relied on affidavits made by senior people in the NPA.
Correct.
So, and if I understand correctly, my learned friends sitting in the court today on behalf of the state are all members of the investigative director in Pretoria, correct?
As far as I know, yes.
Yeah. So they are privy to all of this information. In terms of the restraint order, the accused had to make a disclosure of all his assets. Is that correct?
That's correct.
And in fact, that was done as was required by the order.
That's correct.
And in that affidavits filed by the accused on the 6th of July 2020, he sets out his personal detailed address, bank accounts, assets, everything is dealt with because he was required to do so.
Yes, that's correct.
And relating to this disclosure, has there been any action taken against the accused at all?
Yes.
Relating to this disclosure?
Yes, there was.
So the investigative directorate were closely working with the details of this matter now for a long period of time, since at least 2019, but actively relating to the AFU application, etc., the content proceedings, etc., since middle last year.
Yes, June last year.
Yeah. So we're looking at perhaps 15, 16 months before those applications were filed.
Yes.
After that, those applications were filed. Now, my learned friend for the state put on record that there are certain issues they wish to now investigate relating to the cell phone of the accused. Those were all topics of the search and seizure warrant in November 2020, and the results of that have been canvassed in the High Court already. Is it correct?
I'm not sure about the results. When the warrant was issued in November last year, the cell phones was taken. I don't know whether any results have come out.
Yeah, but that is in possession of the ID.
Correct.
It's investigative director. Let's refer to the ID. So they have had it all along.
Correct.
And if one looks at the draft chart sheet, we have no less at this stage than just see how many accused indicated here: 16, 19, 23, 27 accused, which in terms of this draft order has to be joined in this matter currently before court.
Correct.
Correct. And this is substantial work which had been done on this case, so the state should be in possession of. It's unthinkable that there's anything relevant which they do not know.
I agree.
Which is borne out by the fact that they even knew that the accused was leaving on a golf trip, and then applied for a warrant only on the 28th of September. Let's just go through the other points briefly. The state, my learned friend for the state said they wanted to look at the assets of the accused, the applicant, outside of the Republic of South Africa. Now, this was the very topic of the AFU order, isn't it? And the very purpose of that order, which was granted way back in June, by the 19th of June 2020.
Yes, that's correct.
And the accused cooperated fully, disclosed all his assets, and the curator has been working away on this since then.
That's correct.
So there's no need to, only after arrest, now try and belatedly establish whether he's got any assets outside the country. It's been the topic of this investigation.
All right, that's the case of alleged Trillian middleman Kubin Thuran Moodley. He has indicated to the court there, that is the Palm Ridge Specialised Crimes Court, that any allegations levelled against him, he will be pleading not guilty, and that he is intending to get bail. The state has indicated that it will oppose bail, and that case does continue. We will, of course, revert back to it at a later stage. We do have more news for you at 1 o'clock. Do stay tuned.